My name is Fred Otswong'o. I'm the host of today's meeting. So before we start, I wish to invite you to this training, very important training that we have. You saw the title is patent drafting, but in a very specialized area, the area of ICT and computer implemented inventions. So the aim is to build capacity to those who are interested in drafting patents for their clients or in vendors that have the capacity to prepare patent applications by themselves. So I have a slide share, just one slide or two. Okay, so because of time, I think we can quickly start. We would have liked to introduce ourselves one by one, but I think we are many. We are about 20 or so. So I would like to introduce the main speaker for today's event. Today we are lucky, we are having Dr. Isaac Rutenberg to present, to take us through the course. Dr. Isaac is the director of CPIT, the Center for Intellectual Property and the Information Technology Law at Strathmore. He's also senior lecturer at the School of Law, Strathmore. He's done a lot of publications in the area of IP law and IT. He holds a PhD in chemistry and JD in law, and he's currently a patent agent in Kenya, California, and the US. So he's well-renowned and experienced expert in IP. So he's going to share with us the topic of today, which is broken into sessions, I think 4 sessions. And we will give the floor to him. He can guide us on the best way forward. So without wasting much time, I would like to invite Dr. Isaac to take the floor. So welcome, Isaac.
Thank you very much, Fred. And thank you very much for inviting me to make this presentation. Greetings from very sunny California. No, I'm just kidding. It's not really. I'm not really in California, but we can all enjoy the Golden Gate Bridge as I present on the topic. So I'm going to get right into it. 2 things to mention. If you hear my kids in the background, I apologize. I have told them to leave us alone, but you know kids. And secondly, if my network slows down, please put that into the chat so I know to give it a chance to come back up or whatever. I'll monitor the chat as we go. So great. So I hope everyone is well. And today we're going to cover patents and patents specifically in the field of ICT. All right. This is the outline from the flyer. I will more or less follow this, not entirely. I think the last 2 actually will be somewhat combined into one. But after each of these, I will take a short break for 1 or 2 questions. You can put the questions into the group chat. I will keep monitoring those, and I'll either answer them on the fly or I will answer them in between the sessions. So feel free to put questions into the chat. And yeah, okay. So basics of patenting in under 20 minutes, which is difficult because I usually take about a 3-hour course to do this. So so this is obviously going to be very high level, relatively high level, but hopefully helpful. To those of you who are in the room who know already a lot about patents, I apologize, just bear with me for a few minutes as we do some of the background part. So honestly, this really won't take very long. So patents are distinct from trademark and copyrights, despite what you might hear in the news, in the media. All around the world, people get these confused, and any IP lawyer will cringe as when that happens. As I see some of the people in the room I know cringe along with me. Patents are for inventions and technology, essentially technology. They're defined as a solution to a problem in a technical field or a technical solution to a problem. So, so they are not about items of creativity. They're not music. They're not artworks. They're not anything about branding. All of that stuff is second, is not patents. So leave it out of the discussion today. These are for inventions, and they are government, as all well, as most IP rights are. They're government granted rights. So you have to go to apply. And in fact, Kenya uses the regional office, ARIPO, and KIPI. So we have a dual system of patenting. They are limited in duration and in geography. So a patent is not renewable. Well, you have to pay annual fees. I suppose you could call that a renewal annually. But after 17 years, or well, after 20 years from the date of filing, which is roughly about 16, 17, or 18 years from when you get the patent, it will expire and you cannot renew it any further. It is limited in geography. So a Kenyan patent is only valid in Kenya. You cannot enforce it outside of Kenya. And that goes with any patent. A US patent is valid only in the US. So pretty much the good news of that is that of the 10+ million patents in the United States, almost all of them you can freely practice here in Kenya, because as long as it stays in Kenya, most likely it's not patented here either. So that's good news. You patent a technology, you do not copyright them. You do not copyright them, and you do not trademark them. So, well, you can trademark a brand that applies technology, but patent technologies, also methods and materials, etc. So, there's always a little bit of a debate about, are you patenting the thing or are you patenting the idea? And I think it's somewhat semantic in nature. To me, I think you only patent ideas. You don't patent anything else. You patent just ideas, because KIPI will never ask to see the thing itself. You don't bring in whatever it is you're patenting. They don't want to see it, and they don't want you to deposit one. Unlike the Copyright Office, which does want a copy of whatever it is that you have copyrighted. All right, moving on. These are some technologies that won patents. Compounds, devices, airplanes, things, basically technology. So the thing in the upper left is a transistor, well, the very first transistor. So the patent requirements are all done through a disclosure. The disclosure is the document that you submit to KIPI, and it is unlike any other type of intellectual property right. Well, okay, it's kind of close to PVPs depending on the jurisdiction, but really it's fairly unique. It's definitely different from copyrights and trademarks, and it's long and it's technical. So there are a couple of requirements for the disclosure. One, you must, in the patent disclosure, you must enable and describe the patented technology, what it is you're trying to patent. So what does that mean? It means you're describing the technology, the invention, if you will, in such a way that anybody with similar skill in the art, or well, with average skill in the art, I should say, in the field, average skill, could just read your description and then go and do what it is you've patented, right? So if I've invented a new way of recording music, then I describe it in such a way that anyone who knows a little bit about music recording technology can go and build and use the same technology I've just patented. So I have to explain it that way. I have to enable the skilled artisan to go and also do what I've described, what I'm patenting. Okay, that is so that when my patent expires after 20 years from the date it's filed, it's now in the public domain. It is available for anybody to go and do, and they can do it just by reading my patent. Okay. So you also have to kind of demonstrate that you have grasped this invention. You actually have done it yourself. although you don't show them, you don't actually bring them an example, you have to describe it in such a way that someone could say, oh yeah, this person knows how to do it. They've described it thoroughly. It's pretty clear that they understood it, and here is all of the description to do it for me. Okay, it also has 3 other requirements which are fairly well known. Those are novelty, inventive step, and usefulness. I won't go into too much detail on these. Novelty just means it's new, it has not been done before. Inventive means it is really new, it has not been done before, and the average person in the field would not have thought about it, would not have come up with it. And it's useful, industrially useful. Those are fairly straightforward. It is not required to submit a working example. Disclosure, this patent application that you file has a number of formal requirements and then a number of substantive requirements. And they are all very important, and they all must be complied with when you submit. So the application formally must contain a list of inventors. It will usually also contain an applicant or list of applicants if there's more than one. The inventors are not necessarily the same as the applicants. The applicant typically will be a company if the inventors are employees of the company. The applicant will be the employer. This is very common outside of Kenya. Interestingly, in Kenya, most of the patent applications, inventors and applicants are either left off or they are the same as the inventors. So we have a lot of individuals applying for patents, which is somewhat unusual. But anyway, most of the time applicants are companies. A representative would be you, the patent agent, a patent lawyer, and that would be someone who has been authorized by KIPI to be an agent. The contact information is, who do you want KIPI to send the information to? Do you want it to be sent to the applicant or to the patent agent? Typically, it's better to do it to the patent agent. And the priority claim is, are you, how do I describe this? How are you claiming that a previous patent application is related to this application? And therefore, you should be given the filing date of the previous patent application, not the one that you're filing at the very moment, at this moment. So that's a little bit technical. I can answer questions if people have questions about that. Substantively, the patent application then, so all of the previous stuff is contained in a form that's called IP3, an IP3 form. And the IP3 form is 2 or 3 pages with just the materials I put on the previous slide. After that comes all of the substantive material, the meat of the patent application, if you will. Well, some of this is also well, the title at least is also on IP3. But the patent application itself must contain the title, the technical field, the disclosure of prior art, a background, a brief description of the invention, and by brief, I mean brief, a brief description of the drawings, also very brief, and then the description of the invention. Now that's where all of the real substance comes in. It's very, it can be very long. I have seen descriptions that are 1,000 pages long, and it can have examples. It does not have to have examples, but it's better if they're there. And then claims, which we will discuss mostly today, claims, so I won't say too much about it right here. Drawings, which are also optional. People love drawings. I don't like drawings at all. I try to file applications without any drawings. They are the #1 thing that are rejected for formalities. They're very difficult to get correct, and usually they're included, and they don't actually add anything to the patent application. So I'm not saying don't, but I'm saying use drawings only when they're really needed. And finally, an abstract, which should be only a few hundred words. All of this, by the way, is regulated through the Industrial Property Act, and also you should refer to the Industrial Property Act regulations, which I think are dated 2002. They are very helpful. Okay. So let's move on a little bit to software patents. And I believe we're still in the first section of the presentation. But the question is, who has software patents? Well, a lot of companies have a lot of software patents. And right now I'm looking only at US patents. Google had, 8 years ago, Google only had about 1,000 patents, but they have been really active, and they have been filing just an enormous number of patents. They now have 34,000 US granted patents. Those are granted, not even the applications. So Kenya, by just sort of comparison, Kenya has under 1,000 total for the whole country. And Google has 34,000. You can see that I kind of estimated that if, depending on who you're paying, if you're paying in-house lawyers to draft your patents, some companies have a patent section, and they will have patent drafters within the company. And others use outside counsel to do this, specialized law firms. Both ways work, but it's just a matter of usually cost savings to do one over the other. But I would estimate that in the US you'll spend probably $7,000 per patent, and that's probably a conservative estimate. So Google's patent portfolio cost them over $200 million, which if you're Google, isn't actually that much money, I think. Facebook has not as many, just under 7,000 patents. And the king of patents is IBM. They have been the king of patents for decades now. They have over 142,000 issued patents. In fact, IBM is, they don't really build anything of note. They make patents, they do research, they do patents, and then they license their patents. And that's pretty much their main source of income, is licensing. Okay, use patents wisely. You can use patents in a lot of different ways. You can get your own patents, or you can go and look at other people's patents and do whatever you want with them. If you're not in the same country and you don't make something that gets into that country, and you know that that person doesn't have a patent in your country, then go ahead and use their patent. A lot of caveats there, of course, and I would say always consult with a lawyer before you do anything like that. But yeah, you can but you can also get a strategic advantage. So you can look at what people are patenting and see where they are heading. A lot of times, patents, and particularly patent applications, will be published before even a product is released, and so you can see what your competitors are doing. In this case, we see a lot of people speculating about the iPhone 12 based on what Apple is patenting, and particularly what their patent applications look like. All right, that is the end of section 1. So I don't see any questions in the chat, so I will move directly to the next section. Unless yeah, we'll just move on. If you have a question, you can probably put it in the chat is best. If you raise your hand or something, I think you can also do that, and Mr. Fred will notify me or whatever. But anyway, I'm going to move on to the next section, which is ICT patent specifications. And I see that our meeting has 8 minutes remaining. I'm not sure how that will work. I'm sure Fred will inform us when we get there. So, okay, software patents. Software patents are allowed pretty much everywhere in one form or another. Definitely in the US, you saw the large numbers in a previous slide. They are most numerous in the US, I would say. Europe allows them as well. Kenya allows them as well. Most countries, though, will have some nuances about what is allowed in a country and what is not. So as opposed to a patent on say, a machine, where most patent laws are pretty much the same, the law as applied to software varies quite a bit. And so it kind of does make it difficult to draft a patent application to software that will be allowable everywhere in the world. But it can be done. It can be done. So they protect inventions that involve computers. Here is an example. This is a US patent granted a good decade ago now. And this is to the news feed, Facebook's news feed, okay? So we'll be actually looking into this patent in a fair amount of depth over the next few minutes, or well, the next hour or so. A question was asked, can you register a patent in more than one jurisdiction? Absolutely. In fact, that's very common. You will first file in the country where you're resident. So everyone in Kenya pretty much has to file first in Kenya, but 6 weeks after you have done that, you're free to file patent applications anywhere else in the world. And there are various mechanisms for doing that. This presentation is not about that process, but just know that you can file abroad anywhere, pretty much anywhere, okay? So we talked about the specification. Well, there are various parts of a patent application, and you say, and here we can see the first page of the patent, right? So it has all the vital statistics about the patent. So it has the patent number up at the top, 7,827,208. It was filed. It was granted in 2010. The assignee is Facebook, and it's, as you can see, there are what, 5 or so patent inventors, but probably almost certainly all of them worked at Facebook. And then there's the application number, filing date, prior publication data, etc. Okay. On the next pages after that, you will find the very next pages, you'll find the drawings. And here are 2 of the drawings from that patent application. They're, as I said, technical. They use very technical words. None of these words look like what you would associate with the news feed. But when you put them all together, you know, if you read it in context, then these make sense. And so yeah. These are drawings. Drawings in software usually are just flowcharts, like the ones here. Occasionally you'll see depictions of computers. Here you can see a bubble that is the network. It's sort of a cloudy cloud network image, but that's about as pictorial as you'll get in a software patent. Looking at the questions in the chat, it's great. I won't talk about the limitations of Kenyan law right now. We'll get to that. What is the best way to patent an application? Patents the code, a final application. Yeah, I'll also get to that. And don't worry about the, well, you should worry about the length of time it takes. And that's why software actually is really bad for patenting, or I should say patenting is really bad for software. It takes so long to get a patent. Oftentimes the software is obsolete by the time you have it. So, so yeah, that's just a limitation of, I'll do another 1 or 2 slides, but then I see we're out of time in 3 minutes. So I'm gonna ask Fred in about a minute or 2 to give us direction. Actually, let me just finish this slide and then I'll ask Fred to give direction on time. The specification is what comes after the drawings, or sometimes before the drawings, depending on the jurisdiction, doesn't matter though. And this describes the invention in very great detail. So in the specification, which I'm not going to spend too much time about because drafting, when you're drafting, the specification flows very naturally from the claims. So we'll spend most of our time on the claims. But the specification is important, and it really gives the details of the invention. How does this invention work? What are the components? How do those components work together? What sort of interconnections do we need between the components? How else could we do the invention? How, apart from the primary embodiment, you might say, the most obvious embodiment, sometimes it's not obvious, but usually, what are some alternatives, right? So if you're baking bread, can you bake bread at 200 degrees Celsius Okay, fine, that's the best embodiment. Can you bake it at 210 degrees Celsius? Can you bake it at 150 degrees? So those are alternative embodiments. You have to describe other ways that will work also. They may not give you the best solution, but they are alternatives. And then examples and data. And those are also very important to provide to show that you actually had grasp of the invention itself. As I said, the specification can be very long. It can run to 1,000 pages or more. There is no limit. There is no limit. Although I should say that you are charged per page after a certain number of pages on some international applications. Okay, Fred, I defer to you now to give instructions. It says we have less than a minute on this call.
Yeah. We will re-enter. We'll log in afresh immediately. We are logged out.
Okay, I've answered that one. The other ones are going to be answered very shortly in the presentation itself.
So you are done?
It looks like we are, yes, we're going off to Google Meets now, yes.
I think so. We can leave and join.
Yes.